This week, I have chosen a case about the duties which a director owes to a company. Judgment in the case of Re St George Investment Holdings Limited, Manolete Partners plc and Matta and others was handed down on the 5th of November 2020. The company, George Investment Holdings Limited, went into administration in October 2016. On the 8th of February 2019, any claims which the company or its administrators had were assigned to Manolete, an insolvency litigation financing company. The judgment concerns Manolete's applications for declarations and other orders pursuant to the Insolvency Act 1986 and the Companies Act 2006. The respondents to the application were Dr. Matta, a former director, his ex-wife, his daughter, and MMJ Global Limited, an unconnected company. Dr. Matta had an overdrawn director's loan account. When the company went into administration, the account was overdrawn by £1.3 million. The court also heard that Mrs. Matta had received payments of over £17,000 and that Miss Matta, the daughter, had received over £54,000. Those payments were made through the company's payroll. The unconnected company, MMJ Global Limited, had received £70,000, which Manolete argued was a gift. The declaration sought by Manolete fell into two categories. The first, Manolete claimed that Dr. Matta had permitted the payments for himself from the director's loan account, and at the time of the administration, that loan account was significantly overdrawn. Manolete argued that this was in breach of the duties which Dr. Matta owed to the company pursuant to Section 171 to 176 of the Companies Act. Manolete also claimed that the £1.3 million must be repaid. The second category of declarations was sought under Sections 238 to 239 of the Insolvency Act and related to the payments that had been made to Dr. Matta's relatives and the unconnected company. Manolete alleged that these were transactions at an undervalue or preferential payments. I'll address what the court said about the second category of declarations first. Manolete's application was for determination without a full hearing. The court was concerned with whether it could reach conclusions about the relatives' involvement in the company and whether the payments had been made to the relatives and the unconnected company at a time at which the company was unable to pay its debts as they fell due. The judge held that the court could not reach any conclusion about the evidence during a short 2-hour hearing because there was no ability to probe the evidence in any depth. The judge also referred to the case of Phillips and another against McGregor Patterson, a 2009 case. In this case, the court held that the question whether the company was unable to pay its debts at the time was a question that could not possibly be dealt with on a summary basis. Therefore, Manolete would have to advance its case on these points to a full hearing. The court was, however, able to determine the first category of declarations relating to the director's loan account. As stated, directors' duties are set out in Sections 171 to 176 of the Companies Act. The judge stated that the principal duty is set out in Section 171, which is to act in accordance with the company's constitution and to exercise power only for which those powers are confirmed. More specifically, the director must exercise his power to promote the success of the company for the benefit of its members as a whole. The judge agreed with Manolete's submissions that authorising payments from the company's funds so that the director could fund very significant payments over a continuing and long-term basis was in breach of the duties which the director had to promote the success of the company. Note here that Dr. Matta had used the funds to purchase and maintain a yacht, amongst other things. The judge found that Dr. Matta had taken no steps to repay the loan, and that Dr. Matta's argument that the payments were made at a time when the company could afford to do so was no defence. Dr. Matta was in breach of his duties, and he was required to repay the £1.3 million. For directors of companies, the key takeaway point is that a director must take great care when using a director's loan account, or else risk falling foul of the duties owed to the company. For lawyers, this case also demonstrates that the court will be extremely reluctant to make findings in respect of alleged transactions at an undervalue or preferential payments without a full hearing. If you have any questions about the issues raised in this case, please don't hesitate to get in touch. Thank you.